and welcome to Law Pod. I am Dr Lauren Dempster. I'm a senior lecturer here in the School of Law at Queen's University Belfast, and I'm delighted to be joined by my colleague Dr Dr Shattock today to talk about the law of misinformation. Before we get into the substance of the podcast, Ethan, could you tell us a little bit about yourself?
Yeah, so I'm Ethan. I've been here in the Law School of Queen's lecturing for about a year on that spot. I'm lecturing for a module we now launch for the LM students, the master's students, called the Law of Misinformation. My research tends to revolve around the combination of how we regulate misinformation and the implications on human rights. For example, the right to free expression, but also the right to free and fair elections more broadly as well.
Thanks, Ethan. And we're going to delve into both of those particular points today. But to begin with, could you tell us what the difference is between misinformation and disinformation?
Well, this is a very important distinction, and I think there's two ways of seeing it. The first most important way is that the distinction between disinformation and misinformation is all to do with intent to mislead, right? So disinformation, as a kind of contemporary term, probably has its roots somewhere in the middle of the Cold War, both as a use by the KGB of kind of weaponizing misinformation to influence the public, but also in relation to governments more broadly using information to manipulate the public in the context of politics and elections more broadly. But basically, disinformation, how it's currently used as well, is all to do with an intent to deceive. So it's false information which is spread intentionally with the purpose or motivation to mislead someone. Misinformation, by contrast, is more or less always defined as having a lack of intent. So it's a combination of mistakes, errors, things that the person saying it doesn't mean to mislead, but it does carry falsehood, but not with the intent to mislead. That's the distinction, but I think a different way of seeing it also in context is that because misinformation doesn't necessarily have that element of intent, it is broadly seen also as a broad umbrella of falsehoods, of which disinformation is a kind of subcategory within that. So that's the important distinction, but I think these terms and concepts in reality, both in terms of literature and also how they're used by lawmakers, are ultimately still a bit slippery and still a bit overlapping in terms of how they're used in a contemporary sense.
Ethan, that's a really helpful starting point. So I guess for our listeners, in terms of this space around misinformation and disinformation, one of the terms that we hear the most is fake news, particularly over the last number of years. Where does that fit into this picture?
I think it fits everywhere. And again, there's two ways of seeing this. I think fake news has both a probably kind of more academic, increasingly relevant definition, and also a political one too. I think the term fake news, while it was around in the last probably 50, 60 years, it was most commonly reframed and used probably in the last 8 years since the first election of Donald Trump in the US, in a combination of the primaries and general election in 2016. He used the term fake news to describe essentially anything which he thought was, in his own mind, inaccurate, but also just to criticize the media more broadly and to dismiss opponents of his. That's been used also by leaders like Jair Bolsonaro in Brazil. But it was really meant to be a term to dismiss or negate any criticism from media outlets of a political leader's agenda or narrative. So that's quite political. Academically, fake news refers to really a broad category of everything from the aforementioned disinformation and misinformation, but also advertising, propaganda, satire, and parody. The breadth and depth of that umbrella category is probably most accurately how we use the term fake news in academia and literature, but it also signifies why using a term that broad to refer to what is often meant to be disinformation is not only confusing in a kind of conceptual sense, but also raises questions into how broadly are you defining the kind of false statements that you want to curtail and restrict in a legal sense.
Okay, so thank you, Ethan. So you've kind of set the scene for us then in terms of issues in society, politics, and the academic space. To move now to the law, because I know you mentioned that you're delivering a module this year in Queen's on the law of misinformation. Can you tell us what law exists around this.
Well, it's certainly evolved in the last few years, especially the last 2 or 3 years, domestically and regionally. So domestically, we tend to have two different types of laws which regulate misinformation, either in a more direct or indirect sense. The first is legislation which is geared towards maintaining online safety. And you have, for example, in the UK, the recently passed Online Safety Act, and also in the Republic in the South, the Online Safety and Media Regulation Act 2. Both of those things are laws which are intended to combat the broad category of online harms, including what we call sometimes harmful but lawful content, which includes many forms of misinformation and disinformation. But it doesn't necessarily reference those terms in express sense. So that's more of a kind of an indirect way of regulation of misinformation on a domestic level. What we also have is a more directly bespoke, tailored sense of laws that are geared towards minimizing election falsehoods in pre-election periods. And you have more recently passed legislation in different EU member states, which is geared towards minimizing false information in election periods online. But you also have a combination of existing election laws and also defamation laws, which do, in essence, regulate and restrict falsehoods in election periods, but it's geared towards falsehoods that are obviously unlawful, i.e. defamation, for example. So that's the kind of domestic context. What you also have more recently is what I would call a kind of constellation of self-regulation and more robust regulation in the EU, for example. And you have, most prominently in the last few years, the passage of the Digital Services Act, the DSA. This is intended to signify a very important transfer from what has been for the last 25 years a kind of more strict regime of asking online platforms to take down unlawful content, to an encouragement, in some sense, of platforms being asked to manage and mitigate risks to their platforms, which includes now not just content which is unlawful, but also things like misinformation and disinformation and quote-unquote harmful content. So it's gotten more broad in terms of what types of content we're now regulating, and misinformation is often included in that, but sometimes it kind of falls under the kind of broad concept of online harms.
Would you say the DSA has been effective in terms of managing misinformation?
I think it's still kind of early on. The DSA also is kind of coexistent with the self-regulatory disinformation code of practice. That basically is a, I would say, institutionally nudged piece of industry-led self-regulation. So it's codes, it's encouragement. It isn't necessarily legally binding, but it kind of fosters more transparency from platforms, both in terms of how they manage and moderate misinformation, and also how their pre-existing policies are geared towards minimizing deception and falsehoods. It is, in essence, too early to tell how the DSA is working, but it's quite a vast law. So I think the acid test will be in the next few years when we have some case law, and also when we actually have some transparency in terms of how the variety of different provisions under the DSA are working in the context of disinformation or fake news or whatever you want to call it.
Thanks, Ethan. I want to move now to talk a little bit about the human rights implications. So when we think about the human rights that are engaged here, probably the first one that would come to mind for most people is freedom of expression. Could you tell us a bit about that?
Yeah, I mean, that's the most kind of obviously imminent right? So what a lot of these academics and literature often looks at misinformation regulation in the context of, if we tell online platforms and if we, as a legislature, for example, regulate falsehoods, we then invariably step into the category of we restrict information. Insofar as you curtail access to information, you do go into the postcode of undermining potentially the right to free expression. So that's a cause for concern. But I think the legislation as it stands, both in domestic and regional contexts, it very much encourages platforms and different stakeholders to be, mindful of the right to free expression and balancing the moderation of false content with the protection to access information. That balance is quite important, but the law as it currently stands, in a variety of aspects, doesn't offer that much substance in the way of standards, guidance, really in terms of what do you look for that distinguishes false content which should stay online and false content which should be taken down. And that's where free expression comes in. Most of the laws involved here reference Article 10 of the ECHR, the European Convention on Human Rights. That is the kind of main starting point in terms of there's a very broad category of case law from the European Court of Human Rights under Article 10. And it is the most often cited provision here. So this right is very important. Now, of course, it isn't without limitations. Once a law is, foreseeable, if it pursues a legitimate aim, and if it actually is proportionate in how it unfolds and is enforced, that's crucial. The key point is, based on the existing case law of the ECTHR, to what extent can you regulate, minimize access to false content, especially if this content, as it often is legal, right? It isn't against any specific hate speech law or defamation law, but it still falls into the category of what we conceptualize as being harmful, especially in the election context. And I think beyond the obvious question of, is the content lawful? What you often get in the broad sway of case law from the ECHR is there is an important distinction between false information, which is intentionally false, and false information which conveys some good faith opinion, or just is not based in deception. And that's an important distinction. Likewise, you also have this crucial distinction between information which is false and likely to influence the public and information which probably won't do so. So it's a complex collection of cases, but really when it comes to the analysis of how the court approaches these things, when it mediates the need for a democracy and access to information with the need for veracity and an informed electorate, this question of deception or mistake is fundamental, and also a question of how likely will this false information actually influence the electorate or not. And I think insofar as you can discern that a given piece of false information, for example, in an election context, is deceptive and intentionally so, and if it is prone to influence the electorate, that is more of a justification to take down said content, as opposed to content which is erroneous, mistaken, or some kind of good faith opinion, which is, minimal in terms of its harms or influence on the electorate. That's an important kind of framework in terms of how we conceptualize free expression in this context.
Thanks, Ethan. So you've laid the foundations well there for my next question. And I know you mentioned earlier that you have a particular interest in the relationship between misinformation and the right to free and fair elections. So could you tell us more about that?
Yeah, this is a really important right, which is we often in the legislation and the kind of voluntary codes and literature as well, we often refer to falsehoods and misinformation in the context of free and fair elections without discussing that right in substance. But actually, it's an important right. In the Convention, for example, under Article 3 or Protocol 1 of the ECHR, we actually have the right to free and fair elections, which is an obligation on states to ensure that elections are free and fairly contested. The obvious question is, on the one hand, to what extent does that actually say anything about misinformation in the election context, and also to what extent do legislatures and platforms as well moderate or balance the right to free expression with the need for free and, I would say, informed elections too. So the case law is very much underexplored, and what it often does is set out cases that are very much to do with election procedure and administration, not to do with, I suppose, speech per se, but this case law in a different kind of context still maintains that this notion of deception and influence is really important. In other words, cases whereby the courts assessed, for example, election candidates who lied to election commissions. The extent to which candidates intend to deceive is really important, and also the extent to which election candidates say things that could sway voters in their choice is really important too. And also, again, more kind of procedurally, some of the case law involves a kind of retroactive look from the court at alleged interferences with the election process. For example, someone has tampered with votes, someone has falsified ballots. In those cases, a crucial question is, to what extent did this discrepancy, this error, influence the outcome of the election? And again, like free expression, in different terminology, insofar as it does or will influence the outcome, and insofar as we can discern some kind of intent to deceive, that's more serious. Whereas things that are minor in terms of impact electorally and minor in terms of intent to deceive are of less significance. And I think this notion of deception and influence are actually critically important when it comes to how we analyse the case law in this area, especially with regard to the ECHR. But it's virtually absent from the existing legislation in terms of standards, guidance for platforms, in terms of content moderation. So I think those two rights are so important and so linked, but they aren't discussed as in tandem as perhaps they could be and should be.
Thank you, Ethan. It's really interesting to hear the importance and perhaps lack of attention that's being given to misinformation in the context of a right to free and fair elections. Are there any particular examples you could speak to that our listeners might be aware of to kind of illustrate this?
Probably a few. I think more recently we have the example of Donald Trump actually in the context of a US debate in the election, talking about this fictitious example of, I think, Haitian immigrants in Springfield in the US eating dogs and cats. Now, this, of course, got media attention and it was quite discussed widely, but I think it's an example of, well, to what extent is this statement going to influence the average voter? I would say certainly amongst his base, probably quite a lot, right? Because it's quite a novel, colourful example. So it probably passes that test of this is probably influential to the electorate. And the other issue is, to what extent is this based on deception or intent to mislead or some kind of good faith, credible belief? I think we can discern that this is probably to do with deception as opposed to some belief actually held by Trump. But also, in terms of deception, it isn't always necessarily evident on the face of it whether or not something is based on deception or intent to mislead. And I think the case law often says certain factors or pressure points indicate that deception is present. For example, the extent to which something is against a factual consensus, i.e. if someone denies that the earth is round, it's so far removed from the actual facts that we have that it probably is deception. Also, what the court tends to kind of say in the ECHR at least is that the extent to which someone is saying something false and they hold power in office, that's crucial. In the same way as figures in politics have to have access to a broad set of speeches and opinions, they also have to be held accountable for things that they're saying that are dubious. So in the context of Trump's statements about dogs and cats being eaten, that is probably a communication which requires at least robust fact-checking and probably labeling online too, because it's in that category of deceitful and also at a certain level influential to a certain sect of the US electorate. And I think those examples are plentiful, but ultimately discussing deception and influence is a more appropriate way of forwarding the conversation in terms of how we interpret and look at false statements in the context of pre-election periods and the environment of politics more broadly.
So thank you, Ethan, for joining us today. We will link to your publications in the show notes if any of our listeners would like to read further about this. And we want to just thank you again for your time, and thank you everyone for listening to LawPod.